matter of the Crown on the application of AM Belarus against the Secretary of State for the Home Department.
Lord Sales will hand down the judgment.
When a foreigner comes to the UK, they ordinarily require leave to remain granted by the Secretary of State, or they are liable to be deported. A person may enter the UK in order to claim asylum here, and at that stage may ask for leave to remain. A grant of leave to remain typically carries with it a right to seek employment in the UK, a right to social welfare benefits at a certain level, and a right to have access to the NHS. In addition to being liable to deportation if the foreigner does not have leave to remain, if they commit serious crimes in the UK, they may also be liable to deportation as a foreign criminal. But in order for a deportation to be implemented, it is necessary that the authorities of the person's country of origin accept that they are a national of that state and accordingly allow them entry there. If a foreigner comes to the UK, is refused leave to remain, but cannot be deported because of a problem in securing admission to their state of origin, then by force of circumstances they have to remain in the UK with what is sometimes called limbo status. Limbo status means that, if it is not appropriate to detain them with a view to effecting their deportation in future, they are released into the community on bail. They do not enjoy all the benefits associated with leave to remain, but the state has a duty to protect them from destitution and against inhumane treatment, so it provides accommodation, welfare benefits at a minimal level, and access to essential NHS services, which are more limited than the full NHS service. They are not permitted to seek employment. The present case concerns a man whom I will call AM, who is a national of Belarus. He arrived in the UK in 1998 and claimed asylum, but his claim was rejected. He also applied for leave to remain as a stateless person, but that claim was rejected as well. The Secretary of State attempted to deport him to Belarus in 2001, but AM provided the authorities there with false information, so they concluded that he was not of Belarusian nationality and refused to admit him. AM remained in the UK with limbo status, without permission to seek employment, and with access to the lesser forms of welfare benefits and access to the NHS, which I have described. While here, AM committed serious crimes for which he was imprisoned. The Secretary of State made a deportation order against him and again sought to remove him to Belarus. But again, AM lied to the Belarusian authorities and succeeded in thwarting his removal there. He continued to reside in the UK with limbo status. That has now continued for a very long time. He has suffered ill health and believes his health would improve if he were granted leave to remain, along with the benefits that carries, including being able to seek employment. Relying on his right to protection for his private life under Article 8 of the European Convention on Human Rights, he applied to the Secretary of State for leave to remain. This was refused, so he brought a claim in judicial review to compel the Secretary of State to grant him leave to remain to end his limbo status. The upper tribunal held that the refusal of leave to remain constituted an interference with AM's rights under Article 8, and that since a lot of time had elapsed and there was no realistic prospect that he could be removed, the interference was disproportionate, and the Secretary of State had an obligation to grant him leave to remain. The Secretary of State appealed, but the Court of Appeal upheld the tribunal's decision. The Secretary of State has appealed again to this court. The Supreme Court unanimously allows the appeal. On the appeal, the Secretary of State introduced a new argument. He sought to contend that a doctrine of the European Court of Human Rights, known as the Gilberg principle, after a case of that name, precluded AM from making any complaint at all about a violation of his rights under Article 8. The Gilberg principle is to the effect that someone cannot complain about an effect on their private life which they have directly brought upon themselves. However, the Court does not accept that the Gilberg principle has any application in the present context. The refusal to grant AM leave to remain is the result of a discretionary choice made by the Secretary of State in the light of the circumstances of AM's case, not a direct consequence of his own actions in lying to the Belarusian authorities. Therefore, the case has to be analysed in accordance with the usual principles applicable under Article 8. The Court agrees with the courts below that the refusal to grant AM leave to remain involves a material interference with his right to respect for his private life under Article 8. In the circumstances, the case can be analysed either in terms of a negative obligation on the state not to interfere with AM's private life, or in terms of a positive obligation to take steps to protect that aspect of his Article 8 rights, and it doesn't matter which. Both involve examining whether the Secretary of State was pursuing a legitimate aim, whether the impact on AM's private life was proportionate to that aim, and whether, overall, a fair balance was struck between AM's private interest and the general interest of the community. In seeking to strike that balance in the present context, the Secretary of State enjoys a wide margin of appreciation or discretion. The Court finds that by allocating to AM the limited benefits associated with limbo status, rather than the more extensive benefits associated with leave to remain, the Secretary of State was promoting the legitimate aims of upholding and reinforcing immigration controls and of focusing limited state resources to promote the interests of UK citizens and lawful immigrants. The Secretary of State acted proportionately and struck a fair balance. In that regard, it is highly significant that AM, by his lies to the Belarusian authorities, had completely undermined the strong public interest in enforcing immigration controls by being able to remove illegal immigrants, and further, had completely undermined the even stronger public interest in being able to deport foreign criminals. If AM were able to benefit from the success of his tactics to prevent his removal, so as to gain access to leave to remain and the more extensive benefits associated with that, that would create an incentive for him and other illegal immigrants to seek to obstruct their removal in the same illegitimate way. It would also undermine public confidence in the effectiveness of the UK's immigration controls. On the other side of the balance, AM's private life in the UK is entitled to little weight because it was established at a time when his immigration status was precarious because he was in the UK unlawfully. Overall, therefore, it was fair and proportionate that the state's obligations to AM should be limited to protecting him against destitution and inhumane treatment, as it does, and should not be extended to providing him with leave to remain and the enhanced benefits which are available to lawful migrants.
Thank you. The court is now adjourned.